Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Welcome to the Deep Dive. We're here to unpack complex legal and technical materials, giving you the core insights you need. Today, our mission is about drawing lines specifically, the lines around an invention. We're digging into a really foundational U.S. Supreme Court case that answered a huge question in patent law.
Yeah, the big one. When people disagree about what a patent actually means, who decides? Is it the jury, after hearing experts try to explain it all, or did the judge get the final word? This case settled it.
Absolutely, and this decision really shifted how patent trials work, fundamentally. The case you're talking about is Markman et al. Versus Westview Instruments, Inc. et al. It's a Supreme Court decision handed down April 23, 1996. Justice Souter wrote the opinion, and interestingly, it was unanimous. Unanimous, wow. Okay, and for the record, it was argued January 8, 1996. The lawyers were William Mallon for Markman, the petitioner, and Frank Griffin III for Westview, the respondents. A unanimous decision on something this fundamental. Well, that tells you something significant was going on.
Right. So to get why this is such a landmark decision, we actually need to start with the facts on the ground. And they're maybe less glamorous than you'd expect. It all started with dry cleaners.
It did indeed. So Markman, the petitioner, had a patent, U.S. reissue patent number 33054. It covered an inventory control and reporting system for dry cleaning stores.
Okay, so like an early computer system.
Pretty much, using a keyboard, a processor, tracking clothes, generating barcodes, that kind of thing.
And Westview, the other party.
They had a similar product, also used a keyboard, processor, put charges on barcoded tickets. Markman saw this and, well, sued for patent infringement.
Makes sense. So where did the disagreement come in? What was the specific legal fight about?
It all came down to one word in Markman's patent claim. The word inventory. Inventory. Seems straightforward.
You'd think. But Markman's claim language said the system had to, quote, maintain an inventory total and detect and localize spurious additions to inventory. Westview pushed back hard.
How so?
They argued their system didn't track physical inventory like the actual shirts and pants. They said it only tracked money, receivables, invoices, not the clothes themselves.
Okay. So is inventory dollars or dresses? That was the core question, determining if Westview infringed or not. How did this play out in court initially?
Well, first it went to a jury trial. Both sides brought in experts, people who knew dry cleaning systems, software.
To explain what inventory meant in that business, in that context.
Exactly. The jury listened to all of his testimony, decided who seemed more credible, and they found for Markman. They said Westview did infringe claims 1 and 10.
Okay, jury decides for Markman. But that wasn't the end of it, was it? This is where the judge steps in.
Right. The district court judge then did something pretty dramatic. The judge overruled the jury, threw out their verdict, and directed a verdict for Westview instead.
Whoa. On what grounds? How could the judge just ignore the jury like that?
It's called granting judgment as a matter of law, or JMOL. The judge decided that the legal definition of inventory, when you interpret the patent document correctly as a matter of law, well, that definition included both cash and physical items.
And since Westview's system didn't track the physical clothes,
it couldn't infringe, according to the judge. Didn't matter what the experts told the jury or what the jury believed the word meant based on that testimony. The judge said the legal meaning was different.
That's a massive distinction. The judge isn't second-guessing the facts. They're correcting the definition the jury used.
Precisely. And this went up to the Court of Appeals for the Federal Circuit. That's the specialized court for patent cases. They agreed with the district court judge.
What did they say?
They laid down the rule quite clearly. Interpreting patent claims, figuring out what those terms mean. That is the exclusive job of the court, the judge, not the jury. And that set the stage for the Supreme Court.
Okay, so this lands at the Supreme Court. And the core legal question, Q3 really, is fundamental. It's about the Seventh Amendment, our right to a jury trial in civil cases. Does that right mean the jury has to be the one to decide the meaning of technical terms in a patent, especially when you need experts to explain them? Or is defining legal terms always a job for the judge, a matter of law?
That's the crux of it. Markman's argument Q4 leaned heavily on history. They basically said, look, patent infringement cases have always been tried by juries.
Right, common law tradition.
And back in the 19th century, they argued, juries often had to figure out the meaning of technical terms or trade jargon based on expert testimony to decide cases. So taking that power away from the jury now, Markman said that violates the Seventh Amendment.
So the idea is, if deciding requires judging which expert is more believable about what a term means, that sounds like weighing evidence, judging credibility. And that's fact-finding, which is the jury's job.
That was precisely Markman's line of reasoning. They cited some older cases like Bischoff v. Weathered to support this idea.
Okay, what was Westview's counter-argument then? Q5, the argument that won at the Federal Circuit.
Westview's argument was, well, much simpler in a way. They said a patent claim isn't just evidence, it's a legal document. It defines the inventor's rights, like the deed to a property.
Ah, defining the boundaries.
Exactly. And interpreting written documents, especially legal ones like statutes or contracts or patents, has always been seen as a core judicial function. A question of law for the judge.
Why is that so important?
For consistency. You need the law, the definition of those rights, to be applied the same way everywhere. Leaving it to different juries could lead to chaos.
So the Supreme Court faces this choice, historical jury practice versus the need for uniform legal interpretation. Who prevails?
The court came down decisively and, like we said, unanimously. Q6 and Q9 covered right there. The ruling, interpreting patent claims, including all the technical terms, is exclusively a job for the judge. It's a pure question of law.
A clear win for Westview's position. How did the court justify taking this interpretive power completely away from the jury? What was their reasoning? Q7.
They built their reasoning on sort of three main pillars. First was historical analysis. They looked back at 1791 when the Seventh Amendment was adopted.
Did juries interpret patent terms back then?
Well, the court found that modern patent claims, those numbered sentences defining the invention, didn't even exist in the way we know them until the Patent Act of 1870.
Ah, so the specific thing being interpreted didn't exist back then.
Right. The closest thing was the patent specification, the description. And early cases suggested judges, not juries, were the ones construing those specifications. So the historical argument for the jury wasn't as strong as Markman claimed.
Okay, so history was ambiguous at best. What was the second pillar?
Precedent. Specifically the line between questions of law and questions of fact. They leaned hard on an old but important case, Q8, Winans v. Dinmead from 1854.
What did Winans establish?
Justice Curtis in that case drew a clear line. Construing the patent, figuring out what it means, is law for the court. Determining if infringement happened, if the accused product does what the patent describes, that's fact for the jury.
So Markman made the mistake of blurring that line.
The court thought so. They said the old cases Markman cited were really about the ultimate question of infringement, of what the accused thing did. Fact, not about defining the scope of the patent law.
Okay, history, precedent. What was the third pillar?
This one might be the most practical. Functional and policy considerations. Basically, who is better suited for the job and what serves the patent system best?
And the court said judges.
Yes, they argued judges are trained in interpreting legal documents, looking at the whole instrument, ensuring consistency. They felt judges were better equipped to handle the often highly technical nature of patents.
Even if that involves understanding expert testimony.
Right. The court said any credibility judgment about experts is sort of secondary to the main task. The sophisticated legal analysis needed to define the term consistently within the entire patent document.
And what about the policy part?
Uniformity.
Yeah.
This is huge. The court stressed that patent law needs predictability. If different juries could define the same patent term differently across the country.
It would be a mess. You wouldn't know what your patent actually protected.
Exactly. It would create a zone of uncertainty, discouraging innovation. Making claim construction a question of law for the judge promotes uniformity and certainty, which aligns with the whole purpose of having the specialized federal circuit court in the first place. They also pointed to patent statutes like 35 U.S.C. Section 112, which mandates clear claims, reinforcing the idea that claims are legal definitions needing consistent interpretation. Hashtag tag outro. So, fast forward to today. What's the real impact of this case? Q10, the legal significance. It's massive. Markman created the rule. Claim construction is law for the judge.
And this led directly to
what we now call Markman hearings, or sometimes claim construction hearings.
Right. These are standard now in patent litigation. They happen pretty early on, don't they?
Usually, yes, often before trial really kicks off. The judge holds a special hearing, listens to arguments about what the disputed claim terms mean, and then issues a ruling defining those terms.
So everyone knows the official definition before going into the full trial.
Precisely. It provides clarity. It tells both sides what the patent legally covers. This often helps cases settle, and it focuses the actual trial, if there is one, squarely on the factual question. Does the accused product infringe the patent as defined by the judge?
That clarity seems to be the absolute key takeaway then, Q11. No matter how technical or complex the invention, the language of the patent is treated like any other legal text, like a statute or a contract. Its meaning is decided by a judge as a matter of law.
That's the rule established by Mark Liebman. The judge is the gatekeeper for the patent's scope.
Okay, judge decides the meaning. But let me throw a final thought out there for you, our listener.
Given how incredibly specialized technology is now, AI, biotech, advanced materials, things that absolutely require deep expert explanation for anyone, judge or jury to understand, does taking the job of defining that core technical language away from the jury, the body meant to represent common sense, truly serve justice? Or does it risk making patent trials overly academic, detached from practical reality, all in the name of legal uniformity?
It's a tough balance, isn't it? Getting the technical meaning right versus ensuring the process feels grounded. Something to think about.
Definitely a tension that still exists in complex cases today.
Well, that brings us to the end of this deep dive into Markman v. Westview. Thanks for joining us.